So good morning, everybody. My name is Amanda Britting. I consider myself to be an amateur student of law, self-educating. I don't go to school for this. I am simply just trying to understand and figure out law in Canada because I think it's an area of weakness for all Canadians, and I think it's imperative that anything that I learn, I share for people to validate it for yourself, and or go to a legal professional and validate it with them. But I think it's important because if you don't understand something, then how do you know whether or not you're getting fair justice? How do you know if they are following the principles of fundamental justice if you don't at least have an idea and concept of how the judicial system is supposed to operate? So today is August the 12th, 2022. And yesterday I was in court. I'm acting as an agent for some people some people who are personal to me, friends of mine. And I refer to them as Fred and Pebbles Flintstone. And they were in court yesterday, and we had a win with respect to Rule 136 of the Courts of Justice Act, which is another video. But that's not the only win we had yesterday. A little quick backstory. On May the 18th of this year, I issued, upon the advice of a friend, three motions to three motions to withdraw or dismiss, no chance of a conviction. Three motions to withdraw or dismiss, no chance of a conviction. Now, understand, I've done these types of things before, and they've always failed, and I've always had to go to an appeal, and in the appeal process, I've always won, but that was after the conviction. What I'm trying to do is I'm trying to save the expense of a trial, because essential procedural elements and essential procedural components and essential elements of the charges against the defendants are clear violations against the defendants' recognized and protected human rights and fundamental freedoms. And because their fundamental rights and freedoms have been violated, we need to get these issues out in the open and addressed, because as long as they are not spoken to prior to the trial, it actually increases the burden upon the defendant, upon how much they need to speak to in their defense. So we went in on June 8th, and we presented the three motions to withdraw or dismiss. Now, on that date, I had started delving even deeper into the law, but I didn't think twice about what we were doing. I just knew I had a strong argument. And when we went in, part of the argument at this point, I was starting to educate myself more thoroughly on understanding jurisdiction, and also understanding more thoroughly the rules of law. And the reason why I was doing this is because these are aspects, fundamental, foundational aspects of law that if we don't understand it, then they're going to continue to take advantage of us. So I've been pushing to understand this stuff. And one of the things that I'd come to learn is that when you read an act of legislation, all those sections underneath are actually rules. So think of any act of legislation, be it the Highway Traffic Act, Reopening of Ontario Act, the Provincial Offences Act. Think of those as the rule books, and everything that follows are the rules. So that's where they get rule of law from. The act is the rule book, and the sections that follow are the rules. So use the rules. So on June 8th, we presented the motions, three motions to withdraw or dismiss, and the Crown actually actively engaged in the argument, saying that she had personal matter jurisdiction over us. She had subject matter jurisdiction over us. She had personal matter jurisdiction over us. She had neither. The court confirmed that they had jurisdiction over us. So they all fought to confirm we had jurisdiction over us. And then we proceeded to the argument, and then towards the end, the judge actually gave rulings. Now, the only authority the judge because the judge lacked authority on the motions, the only thing the judge should have said was, "I don't have the authority as I don't have jurisdiction. I can't give a ruling." On the contrary, though, the judge, or I shouldn't say judge, the justice of the peace this is me talking too fast now. The justice of the peace, in fact, gave rulings and gave grounds for those rulings, including, I think, one of the grounds that the justice of the peace gave was that the government most certainly does have the right to impose laws on you, which actually they don't, and it's unconstitutional, and we all know it. So, the act of allowing us to present, the act of engaging with us in the argument, and the act of giving rulings, actual rulings based on grounds, even though they weren't founded in law, but gave grounds for why they're giving rulings, is an act of deceit, because it led us to believe that we had been heard and we lost. So we elevated it to the next level, which was to do a judicial review at the Superior Court of Ontario. Now, at this point, I now understand, at this point of timeline, I now understand that I have to use the rule book. So I go back to the Provincial Offences Act and I look up the rule for certiorari, mandamus, or prohibition, and that falls under rule number 140. So using rule number 140, I produce an application to the Superior Court of Ontario, serving all the parties according to the rule, and serve all the parties. And I'm seeking a writ of certiorari. In other words, I want the court to quash the ruling from the for the motions that were heard, and whatever other relief the court is willing to give. The other relief the court could give, the way that's worded, is to give us also a writ of mandamus, which would be to order the lower court to follow the law. So we did that and I served it. And then on July the 15th, we get an email from the Crown informing us that we don't have jurisdiction, that this is supposed to be a matter for appeal, but you have to have the conviction first before you can go to appeal. In other words, they're trying to convince us that we don't have jurisdiction and we need to have a trial first. But problem is that, as I've already established, we have a major issues with the essential elements and major issues with the essential procedural components, all of which violate the recognized and protected human rights and fundamental freedoms of the defendants. So I'm going to share the paperwork that followed all of that brought us up till yesterday and brought us up to what I chalk up as another win, because again, they continued in their act of deceit. I have it on documentation. I've already filed complaints with the Judicial, the Justice of the Peace Review Council. I've already started to file complaints with the Law Society of Ontario, because I'm putting all of these people on complaint. And I'm going to be sharing exactly how those complaints are written, because you have to remember, when you file complaints against these people, you can't file a complaint because of the decision. You have to focus and remain focused on their actions and how their actions bring disrepute to the judicial system. So I'm going to end this video here. And I'm going to say, please look for the next video, which I'm going to be doing. If you like the information that you're getting, please like, subscribe, and share, because I think it's important we get this information out to all Canadians. And I thank you very much.